Some viewers may find the following video disturbing. Viewer discretion is advised.
I don't usually place that in, but when it comes to this type of thing, I know it can make some people sick, which does include myself, but we do need to expose them whenever we get the chance to warn the community. Out of all of the numerous things I hate these things the mostest.
We have a sentencing of the Jonathan Nixon filed. So you want to state your opinion for the record?
Mr. Ransom, on behalf of the people.
James Gilbert here on behalf of Mr. Nixon.
All right, and we're here for sentencing on accosting, which is a 4-year felony, guidelines at 0 to 17 months.
Your Honor, yes, I do have scoring challenges. My client pled to accosting for immoral purposes based off of pornography that had been viewed in the home. And so I believe a lot of the scoring is based off of, as much as I respect the probation officer, a lot's based off of her narrative that we don't necessarily agree with, and how the children were treated. And so pretty much every place that was scored, I have an issue with, because it wasn't based off of anything that was admitted to by my client to this charge. So the first one would be OB3, physical injury to a victim, based off of what was admitted to. There was no physical injury, so we'd ask that that one be scored as 0.
Well, I mean, when he pleads to in a couple, well, Mr. Radsman, what's your position with that? I think that's going to affect a lot of the OVs here. What's your thought about that argument?
Judge, I guess the behavior here, certainly there was psychological injury. I mean, our victim is in intensive counseling and will probably be so for a long time, if not for the rest of her life. I can't say there was a bodily injury requiring medical treatment. However, there were certainly phrases, certainly secondary to the psychological injury, self-harm behaviors. So,
well, I mean, in terms of, well, the OB3, I think, is based upon the touching, where the complaining witness said that it made her bleed, and the defense is saying, well, gee, but I didn't plead to that part. So what's your position with regard to that?
no, Judge, I mean, he pled to what he pled to, and I understand the other part, perhaps to an upgrading sexual conduct.
Well, I'm not sure I agree with that, Mr. Gilbert and Mr. Radsman. I mean, when Mr. Mixon pleads to accosting a minor for immoral purposes, and then, you know, he's done a bunch of different things to accost that child, and for purposes of establishing a bare factual basis for the plea, he admits to one little half piece of it. I don't think that means he's insulated from the court considering the whole conduct of accosting for immoral purposes. The sentencing offense is accosting. The sentencing offense is not showing pornography to a child. So I'm considering all of his conduct in accosting this child as for scoring purposes. So I think there is a basis for OB3 at 5 points. Any other challenges, Mr. Gilbert?
Well, yes, Your Honor. I guess then I'll take it back to the actual charging document. He wasn't charged with any type of penetration, even in the initial one. So that would be where the physical, as the court just pointed out, that's where the physical injury would be coming from. So if it wasn't even charged initially, there was charged in the second, I would still argue that OB3 should be a 0, as is OB11, which requires penetration.
Well, but that happens all the time. So somebody can be charged with charged or convicted of an OB or of a CSC2, but if there was a penetration, I mean, that's why we score OB. That's why OB11 exists sometimes. So I guess that doesn't make a lot of sense to me either. I mean, if his conduct in accosting this child did include penetration, which it sure sounds like it did, I'd score that. Just him saying, well, I didn't admit to that part doesn't insulate him from that.
Okay, well, just so I have it on the record, Your Honor.
Sure.
So I guess I would, based off of not being charged with it and what he pled, I disagree with OV3, OV4, OV9, OV10, and OV11,
Okay,
as well as OV13.
okay, and I would reject all those challenges.
Okay.
Mr. Redspon, any scoring challenges from the people?
I know, Judge, I think it's scored appropriately.
All right, and Mr. Gilbert, anything you want to say on behalf of Mr.
Basically, Your Honor, is my client did admit some wrongdoing here. I would ask that the court follow the guideline range and sentence somewhere between 0 and 17, if that's where he falls, and not exceed the 17. All the factors, because the court has pointed out, he's received points for everything that could possibly have happened, and so that scoring range does seem appropriate to what he pled to, and considering those factors are there. So I'd ask the court to stay within the 0 to 17 and possibly consider county time. He has sat for quite a few days already before he was released on bond. Thank you.
Mr. Mixon, anything you want to tell me, sir?
I don't really have nothing to say, Your Honor.
Okay, thank you. Mr. Redspon, any recommendations from the people?
Yes, first of all, Judge, I want to make sure the guardian for the children did prepare a statement dated November 12th. I want to make sure you have.
I was able to review that, yes.
Okay. She is present. She asked if she could make a statement. I don't know if it would be anything different than what she had in writing, but I'll leave that up to the discretion of the court.
Okay, I was able to read the written statement, but if you wanted to make a statement to the court, you can certainly do so today.
Where do I stand?
Just right there is fine, or you
Okay.
can stand at the prosecutor's table if you want, or just behind the bar, whatever you prefer.
I shaking right now. This whole situation has uprooted my whole family. When we took guardianship, we were not aware of the sexual or physical abuse of the 2 children. I want to make sure that it is on docket that there were 2 children that were abused. Why one of the children's case was dropped, I do not know. But these children are still coming forward with new information. A new 3200 CPS report was made with new information that was disclosed to the counselor. And that's going to be the case with trauma. As they get older, they get more comfortable, they feel safer, they will continue to disclose more information of the abuse. I do not agree with the plea that was offered. I don't know if you have the jurisdiction, if the court is able to reject the plea, but this goes beyond accosting a minor for immoral purposes. There are 2 young children that were abused, and they're going to spend the rest of their lives in trauma therapy because of it. Just last night, even one of them had a nightmare about John, and she came running up the stairs crying. This isn't something new. This is something we've been dealing with for 2 years. And I asked the court to not be lenient on him, because these children don't have that option. They have to spend the rest of their life dealing with this.
Okay, thank you, ma'am.
Thank you.
Mr. Redspon, any recommendations, sir?
Your Honor, in reviewing this, I see the department has recommended exceeding the guideline range, and I'm in support of that recommendation. I think this was egregious grooming behavior on the part of the defendant, and I think it justifies exceeding the guideline range here.
Thank you. Well, Mr. Mixon, you're 52 years old. You have 6 prior felonies. One of them is a sexual offense against minors in 1998 in Alabama. So you're a repeat sexual offender. In this case, you were grooming 2 kids and abusing one of them. You're, as I said, a repeat sexual offender. That isn't taken into account in the guidelines. And I have no authority over the charge in a case when it's lawful. So that's up to the prosecutor and the defense to sort out, through charge bargaining what the charge is. You're convicted of accosting with a 4-year statutory maximum. The most that's within my power is to sentence you to not more than 2/3 of the maximum. And that's what I'm going to do. I'm going to give you the maximum that I can because of the repeat nature of their sexual offenses against children, sir. I'm going to commit you to the Michigan Department of Corrections for not less than 32 months, no more than 4 years. You do get credit for 174 days previously served. There's $130 in crime victims assessment, $68 in state costs, and $350 in court costs. That is an upward departure from the advisory guidelines. I've placed my reasons for that on the record, believing it to be a proportionate sentence to the circumstances of the offense and the offender.
Murdering a childhood should be a capital offense, and as such, there should be only 2 sentences, life or death. Let me know what you all think. One thing I do know, I'm starting to like this judge. One thing I do know, I'm starting to like this judge. If you are new to my channel, please subscribe as I edit these cases and remove all of the mundane, boring, repetitive stuff. And I even remove the silences, so you get only the juicy bits, which I think are always the best bits. Are looking for another episode that has all the boring stuff cut out and gives you just the good stuff, then here a couple that may interest you. Enjoy.